seminar before, and so some of this information will be repetitive, but it's a good refresher if it's been a little while since you've been here. If you've never been here, welcome. I'm glad you're here. This is a little bit different kind of presentation in that I definitely have slides and information that I want to present, information that I want to make sure that you take away from here. But then a lot of this is a community discussion. So I know you come with questions. I'm going to try to answer those as best I can. Obviously tonight, and that brings us to our first slide, is not legal advice. The only way I take a client is if I enter into a written engagement agreement between my firm and the association or the developer or the individual. And so tonight's a conversation. It's not a attorney-client providing legal advice, okay? So sometimes there's, just one second, sometimes there's an individual that comes that knows I represent a certain builder, developer, association, wants to try to pin me in a corner, and we're not gonna do that, all right? But I will answer as many questions as I possibly can. Yes, sir?
Are copies of the slides available either through the internet?
They are online at Neighborhood Alliance's website. Yeah.
And actually what we're going to do, we're going to email those to everyone who's in the class. So they're
Oh, thank you very much.
You know, those who take the class and access them.
And we can pass those, we can be able to pass those on with no problem to our homeowners.
Sure. Yeah, but if you start selling them, you got to give me a cut, okay? If you start selling them and are actually able to sell them, I'm going to hire you as a marketing expert. All right, so one of the things, and I'm happy to answer questions as we go along, just don't get offended if I tell you, all right, that's a good question, but we're going to cover that in just a second, all right? Because we've been doing this, goodness, I don't know, actually disappeared. It's maybe 10 years now, a long time. And I've been practicing this area of law for about 17, 18 years. And so a lot of the questions I've anticipated, but and that's what makes this conversation fun for me, is because there's always a question or a fact pattern or an issue that I haven't come across. You know, there's something new every time. So that's always exciting for me. But let's start with the basics. And sometimes we suffer from a lack of language. There is no statutory definitions or language that we're given in Oklahoma. If you go out on the internet, and you're going to hear me say this a couple of times throughout this series, but if you go out on the internet, you're really running a risk of confusing yourself. I was at a HOA meeting last night. Individual got fairly bent out of shape because they had done the research as far as they knew, and wasn't exactly accurate about what we were talking about. So I'll give you an example. Sometimes it comes up and people are adamant that, well, when the developer sells 75% of the lots, they have to transition, they have to hand it over to the owners. You hear that all the time. Well, that would be true if we lived in Colorado or Connecticut, one of those other states that have adopted what's called the UKIOA, the Uniform Common Interest Ownership Act. We don't have anything of the sort in Oklahoma, and so there is no 75% rule in Oklahoma. And what it comes down to, if that is your question, when does the developer have to get out? We go to the governing documents. That's why this is, for us, we don't start with the law. We'll talk about what the law is in a second, but we start with the governing documents because almost, well, I'll say a large percentage of the questions that we have are answered not by Oklahoma law, but by our governing documents. All right? So what are the governing documents when I'm using that phrase? I'm talking about a plat, a set of covenants, and these covenants can be called owner's certificate, deed of dedication for our Tulsa folks. And this is a little point of departure. Depending on where you are, there might be variances in the development style. And in Tulsa County, Oklahoma County, there's a pretty divergent style. So in Tulsa County, you'll see a plat filed, and then along with the actual plat itself, you'll see language called deed of dedication. And you'll have all these covenants that are filed along with the plat. Well, and that's a valid way to do it. In Oklahoma County, you don't see that. You see the plat get filed, and then you see separately covenants get filed. All right? And so when I'm talking about a plat, this is what it looks like. Now, I know you can't read the detail, but this is what a plat looks like. And you can pull these typically in an 8.5 by 11 format online. If you go pull the actual plat that's recorded at the county clerk's office, it's going to be on Mylar, sometimes called vellum, not actual vellum, but they call them that. And they're large, all right? And the plat answers questions like, is there any common area in our neighborhood? Is there a drainage easement that the association or that individual owners have to maintain or take care of? It'll answer the question, are we a gated community? Are we private streets? Are we public streets? And it may, in fact, answer questions like, do we have a mandatory association? You know, these are all common questions that come up and that people call my office or email me, hey, is my association mandatory? Do I have to pay these dues? They keep sending me this piece of paper that says I owe something. Do I have to pay it? And we actually start with the plat to answer that question. Because in Oklahoma County, a lot of surrounding counties, there's going to be a plat note like this. You can't read that, but it says, I can't read it, but I know it says notes. And what it says is the common area shall be maintained by a property owners association comprised of the lot owners. That's covenant language, but it's contained on our plat. That's creation language. Now, hopefully we've got more language, because that doesn't help us out a whole lot. It doesn't give the association lien rights, doesn't tell us dues amount, anything like that. But that is creation language. It answers the question, do we have a mandatory association? Yes. Who are the members of the association? It's the lot owners. So the plat can have really good information for us. The other documents that we're looking for are covenants. Now, this is when language also becomes important when we're talking about covenants versus bylaws. Now, sometimes people, and I'll gently correct you tonight if we get into this, but you ask the question, how do we amend our bylaws? Well, I'm going to be heading down a corporate amendment answer, because bylaws are a corporate document. They tell us the business of the business. What's the name of the corporation? How often do we meet? Do we elect directors? Do we elect officers under some bylaws? What kind of notice? What kind of proxies? What kind of access to books and records? These are all business corporation questions. And you amend that document, the bylaws, differently than you would amend a set of covenants. And so we can't interchange those terms. Covenants are the use and structural restrictions that get filed with the county clerk's office, just like the plat does, that tells us what we can and can't do with our property. How big does my house have to be? Can I run a saloon out of my garage? Can I lease my property? Can I lease it for vacation rentals, like on Airbnb or something like that? Or do I have to lease it for 12 months? Can I have a horse in my backyard? All right? So these are all use and structural restrictions. Then we would find those in the covenants, and it doesn't make any difference whether the covenants are entitled declaration, owner certificate, restrictions, and it doesn't matter if they're filed in with individual deeds. Sometimes you see that. Hopefully not, because that's kind of a mess, and it indicates it's a older, somewhat unsophisticated development style. But those are just as valid, just like plat restrictions or separately filed covenants. Okay. I'll go ahead and say this, and I'll say it again on another slide, but your association, it doesn't have to be incorporated, but it really needs to be incorporated. We don't let each other operate businesses, even nonprofit, non-stock ones, in an unincorporated entity. So if we all decided tonight we were going to pool some of our money and improve a piece of property. We may own it, we may not own it, but say we have the right to improve or maintain that piece of property. we are operating as either a partnership or an unincorporated association. We've pooled our money, we're a group of more than one individual, and we're operating for a common purpose. So if liability occurs, whatever that liability is, we would each have individual personal liability. So all that money I've socked away to retire, unless it's in an IRA in Oklahoma, which is exempt, general savings account, I've got an account created for each of my 4 girls. It's absolutely attachable if I've got personal liability. There's no reason in the world for us to operate that way. So what you do, hopefully I've scared you enough that you're going to make sure that your association's incorporated. And if you don't know, and you can't find a document that says Certificate of Incorporation in your governing documents file or your binder or whatever, then you can go to the Oklahoma Secretary of State's website and you can run a search, probably for the neighborhood name, Happy Acres, whatever. Do a search under the business entity for your addition name and see if it's incorporated. If it's not incorporated, it's very straightforward and simple. The forms are online with the Secretary of State's office. That's a $25 filing fee, and you can incorporate it. I would strongly encourage you, if you have covenants, and those covenants define the name of the association. So for example, if the association is defined within the recorded covenants as Happy Acres Homeowners Association, that you incorporate that name. Not Happy Acres Property Owners Association. Because what you're doing is, if you do Property Owners Association, you're creating a question. You're creating a problem where we don't need one. Is that the association? Well, no, it's not the one named in the covenants. Name the association according to what the covenants have designated. Yes, sir. You had a question?
SC or LLC, or is it specific just for homeowners?
It's an INC. It is a nonprofit, non-stock corporation. It is allowable under Oklahoma law to form an LLC for a non-stock, nonprofit homeowners association, but there's a number of reasons why you would not want to do that. Yes, sir.
So do I understand you correctly, there are no Oklahoma statutes on the books about HOAs?
No, definitely didn't say that. There are.
Okay, then I thought you said there's no Oklahoma statutory laws or something. You had to live in Colorado to have statutes.
Yeah, that comment was limited to if the question is, when does the developer transition to the association?
Okay, so
There is no Oklahoma law on that.
thank you.
Yes, sir.
Can you repeat where to go to see if we are website or?
Go to the Oklahoma Secretary of State's website. There's a function called business search, business entity search.
What was that again, Oklahoma business?
Oklahoma Secretary of State. If you Google Oklahoma Secretary of State, it'll give you the link for that site.
And we're looking for our particular organization now.
That's correct.
And the only will be listed if we're incorporated, or it'll tell us if it is or is not incorporated.
If it is incorporated, it will be listed there. Now, usually what you're looking for is some variation of your neighborhood name. You're looking for, every corporation has to have a registered agent, flesh and blood designated, who serves as the, well, I say flesh and blood, it can be a corporation actually. Usually the association's registered agent is going to be the developer's name, the developer's entity, could be someone that is a former president. It could be the attorney, could be the CPA, could be the management company, it could be just about anybody can serve as registered agent. You just have to have a non-PO box address.
How would that be affected by an association that chose to do a DBA? Because the Plat it's on and the reason that it's on was, just say, complex from the beginning, and the homeowners chose to do a business as different than the actual what's listed in there, and it's registered as, would that make a difference?
Well, a DBA is, DBA could be an unincorporated association. It could be, so for example, I practice law as Matthew L. Winton PLLC. I have a DBA, a trade name report under Winton Law, because that's what the sign says out on the door. So it doesn't necessarily mean if you're operating as a DBA that you have an unincorporated entity, but you want to check that out and make sure that the association isn't operating under this name, but it's an unincorporated entity.
If the developer was incorporated and was that, the fact that we went to a DBA, will that negate that? Or?
This is a little different than the slide sequence, but and that's not a bad thing. I think it's important for us to do this. I'm going to draw a diagram. So when you have, typically in development, you'll have developer LLC, and that developer LLC owns lots, sells lots, and say this is the Plat. So the developer LLC owns all of these and then sells them off, and then say one of these is common area. Up here, you're going to file, so I said this was the Plat, then you're going to file a document, we'll call it the CCRs, the declaration. Covenants, conditions, and restrictions is where that CCR comes from. It's just kind of a shorthand for the covenants. And those CCRs are what create the Homeowners Association. And then we'll have the incorporation documents. Now the developer doesn't have to be a limited liability company. It can be an INC, it could be a sole proprietor, whatever. That is a standalone, it's its own entity. That's a privately owned company. The HOA, once it's incorporated, is its own entity, and typically it's an INC, and that continues. So sometimes there's questions about, well, we don't have to incorporate because the developer's an LLC. Well, we're talking apples and oranges. The Homeowners Association is a completely separate entity. And then sometimes we hear, or we have discussions about, well, the Developers Association, but what about our association? Well, there is no developer, our association. It's all one association. It's just who's controlling that association, who's serving as the board at that particular time. Usually it's the developer, necessarily it's the developer starting off, but then at some point it's going to transition to the resident owners once you've sold enough lots. Developer is going to transfer title of the common area from the LLC to the Homeowners Association, and now we have a fully functioning, intact, resident-driven or controlled association. So all that makes sense? Okay. So that's kind of a mini development sequence. And it may be you have more questions about developer transition. We can talk about those. So let's talk about the law. There is some Oklahoma law. It's not very developed. And this slide pretty much contains all of the statutes for Oklahoma law. So let's talk about the different kinds of community associations or different kinds of developments. And one is, if I use the term unit ownership estate, you probably wouldn't know what I was talking about. But in Oklahoma, that's the term for a condo. Now, a lot of times people think when you're talking about a condo, you have in your mind a certain type of structure. And I do the same thing. I'll talk about, I'll see something that looks like a townhouse or houses that are close together or converted apartments. We just, kind of out of force of habit, we call them condos. Well, a condo isn't a structure. A condo is a type of ownership. It's a form of ownership. So think of it more like leasing. Leasing doesn't have anything to do with the structure. It has to do with the property rights, right? Well, condo is kind of like leasing. I can condo the chair that you're sitting in. Under Oklahoma law, you can condo a church pew. That used to be really common back in the 1800s. So we don't do that these days, I guess. And so we have a Condo Act. If you look that up, it'll say the Oklahoma Unit Ownership Estate Act, and that's what it's talking about. It's a very old set of Oklahoma statutes. It was adopted in the mid-60s. Hasn't been updated, and it's just kind of sat there. The next section I've got as an HOA Act. HOA is kind of short form abbreviation for Homeowners Association. You're going to catch me using the term HOA for both condo associations and owners associations. I'm sorry if that's confusing, but I do the same thing everybody else does. These are in Title 60. And by the way, you need to be familiar with this website if you're not. Partly from entertainment standpoint, partly from education standpoint. And those of you that are laughing, you can look up all your neighbors' divorces and speeding tickets and all of that stuff. Several times. Yeah. Well, it's fantastic. Oklahoma is not just from, again, the entertainment standpoint, but the fact that Oklahoma makes available every single piece of its law, and it's free.
It's free.
It's great, and we've had it for years and years. I mean, this was transformative to a very young lawyer's new law practice, where those paid services that you get case law and statutes, and you pay several $100s a month for, which I couldn't pay for. I can't afford that. You don't have any money coming in when you don't have any clients, right? Well, right when I first started practicing law, they came out with OSCN, or it was just getting developed, and it's fantastic. So OSCN, if you go to this website, it'll pull up a screen, and in the upper left-hand corner, there's what's called a dialog box. It's where you can move your cursor, and then you can type words on the screen, right? Well, if you type 60 space OS, don't worry about the periods, and then 501, that's going to take you to Section 501 in Title 60, which is the first section in our Unit Ownership Estate Act. You could do the same thing with Section 851 of the HOA Act. It's called the Real Estate Development Act. And that, I used to be able to say it consisted of 7 sections. For the life of me, I have no idea why our legislature does this stuff, but we now have Section 858, which is the American Flag Protection Act. So in Oklahoma, we have, by state law, the right to fly the American flag. I guess nobody told our state legislature that's been federal law for probably a decade now. I don't know if you remember that Virginia case where some incredibly brilliant homeowners association board decided to sue a United States Marine flying his flag in his front yard, saying it was a covenant violation. They lost the case, and they also, I guess that's losing the battle, losing the war too. They lost the case, and then the U.S. Congress passed a federal law saying, well, of course you can you can fly the American flag, and it's not a covenant violation. So that's been the law, federal law, for years. But now it's Section 851 through 858. And basically what this real small handful of statutes says is, this is how you create a homeowners association. This is what the association generally can do. And if the association or anybody else in the neighborhood subject to covenants sues to enforce the covenants and wins, then they can be awarded their prevailing party attorney's fees. That's in essence what the Real Estate Development Act says. Okay? Title 18 is, starting at 1001, is our general corporation code. And there's a handful of statutes that specifically apply to nonprofits. Section 1060 is kind of the big one for homeowners association. Doesn't apply if you're not incorporated. All right. So that is generally the law that applies. Now, I'm going to skip these slides because they typically don't have a whole lot of questions about it. Sorry, registered parliamentarians. But we're going to skip this. There are some pretty good case law in Oklahoma dealing with, does Robert's rules apply? What is a quorum? Those kinds of things, and they'll be on your slides. We have a growing body of appellate decisions, and just FYI on what the law is in Oklahoma. The law is what the legislature adopts, and a certain number, not all of them, but a certain number of cases that go up on appeal to our state Supreme Courts, and then of course if the rarity that goes up to the United States Supreme Court, those might be law as well. So the law isn't what we can find on the internet. The law isn't what may have happened in a neighborhood close to ours. It's not what happened in Texas. It may be that for your neighborhood, say for example, if there was a lawsuit, it was litigated to a final decision, that could be the law for your association, because your association was a party to that lawsuit, but it wouldn't be for some other association, okay? So the law is what the legislature says it is in terms of statutes. It's published cases, meaning you can go on OSCN and you can look and see the cases that are published. It's not just the ones that have been decided by the Supreme Court or the Court of Civil Appeals. All right? I already covered this a little bit. Gave you the definition of unincorporated association, and I'll just reinforce, make sure this is at the top of your list. Don't put, okay, the lawyer said we can fine them and file liens, so we're going to do that. Don't make that the top of your list tonight. Make checking to make sure that your association's incorporated. Make that the top of your list. All right? We'll get to fines and liens later. One of the things that I do, like I said in this introduction, or the first part, is I want to give you a lot of information and make sure that there's some practical things that the associations are doing. Call it working myself out of a job, call it, these are things that I find over and over again, and they're fairly simple. They're procedural things that we can minimize the questions, the disgruntlement of our members, and I'm making the assumption that most of y'all here tonight are board members. There's not a whole lot of people who would take an evening or two out who are not on the board. Bless your heart if you are. Thank you for being here as well, but I'm making the assumption that most of y'all are driving the ship, or steering the ship, driving the car. So one of the things that we can do, and call this customer service, call this meeting, fiduciary duty, whatever you want, but doing certain things keeps angry people from blowing up your email, your Facebook or Nextdoor or whatever, and it's just pretty good business practice, and that's having regular meetings. Now, I'm not saying you have to invite every disgruntled owner to your board meetings. That's not it. But having at least an annual meeting, right? And providing some mechanism for a forum, whether it's on a biennial basis or at your annual meeting, but having some kind of set system so that people know what they rely on. I mean, those times in your life where it seems like things are in upheaval, it's disquieting, it's unsettling. And so one of the very simple things the board can do is have an annual meeting set and keep it, right? And if you're not going to keep it, communicate the reasons why you're not, right? Yes, sir.
What happens if the documents say you're supposed to have an annual meeting and you don't? Is there any legality in that?
Yeah, if you're incorporated, what it says, because usually at the annual meeting you elect directors, right? And that's the big question. So who's in charge? And if you're incorporated, what the General Corporation Act says is, well, those people just continue in their position unless, of course, they resign or die until their successor is elected. So there is a built-in continuity there. If we get in the situation where the board isn't calling the annual meeting because they know they're going to get tossed out, then there is a mechanism for individual owners to call a special meeting or force the annual meeting. And if the board is so entrenched that they say, well, we're going to ignore the special meeting request or petition, then you can resort to the courts. There's a specific statute that allows for a court to oversee a corporate election. And let me tell you, that is not going to be a happy judge. I think the things that judges hate most is lawyers acting like children and homeowner association people acting like children. That seems to get them pretty riled up. Yes, ma'am.
Okay. We have 19 lots owned by 11 or 12 people. It's never been incorporated. It's very loose. In fact, we have a very primitive covenant. We know we need to bring that up. But is it, and everyone gets along and it's a happy family until all of a sudden, not bad mouthing, but all of a sudden Buddhist monks have built this constant stuff. So we decided, someone said that we had to have a meeting every year to keep our covenants intact. No? Okay. So we're just trying to get kind of together now on stuff.
So do the Buddhists own a lot within the development?
The people that sold it to them, who were homeowners, didn't inform the other homeowners. They let the city know, and everybody in the world know, but the neighborhood. So they're quiet, but I mean, we've got Buddha statues that are 15 feet high and everything, and we have to always call. They're building something now, so we call. Do they have a permit? No. We better send someone out. So now we have to stay on top of it. So that's one reason that we're wanting to get all our ducks in a row.
I'm going to leave my answer to the question, and that's, do you have to have an annual meeting to keep your covenants up? And the answer is no, because there is...
Trying to now, we have been since they moved out there, but...
There's a lot to discuss with that scenario, and a lot of overlapping rights. Individual private property rights versus constitutional protections.
Right. Well, we've learned a lot of those.
There's a lot of discussion there.
It is neat. They are neat, though.
That's good.
What if the entity not holding the annual meetings is a developer?
Well, again, we can go to this. So developer controls the association, and the developer is not calling, the developer board, let's call it, isn't holding the annual meeting. It's the same answer as if it's a non-developer board. Same thing. There's no cinched up liability because it's a developer board versus a non-developer board.
If they go over a year, the lot owners can test the way they're running it?
Well, whether they're having an annual meeting regularly or not, a member could contest how a board is running the association. Those are two separate issues. If, again, whether it's a developer-controlled board or an individual member-controlled board, if they're not holding the annual meeting, then typically what you do is you send an email or a letter that says, hey, why aren't we having our annual meeting, and get it scheduled.
But there's no legal consequences.
Absolutely, yes. There's a provision in Title 18 that if a association board, a corporate association board, refuses to have their annual meeting, and the members, there's a percentage of members who can petition, go door to door, get your signatures, you give that to the board, and they have to call a special meeting or hold an election. Most of the time, if we're at that point in the conversation, they're going to ignore the piece of paper, they're going to find a reason to challenge the signatures, and you end up in court. So yeah, you have a series...
Into a contest.
That's right, and that's the language the statute uses, is a contested election.
So if you had an LLC, though, would you need to have a meeting every year? Is it mandatory? whatever it was, we're supposed to get.
The answer is probably because, and this is where an LLC really fails for homeowners association. An LLC uses what's called an operating agreement to flesh out the authority, the voting, and that's a really different kind of document than traditional corporate bylaws. So the answer is more than likely the operating agreement would answer that, but not necessarily.
And I didn't want to sound like that, just because they're Buddhist, we didn't want, we're not talking Buddhist, we've got a monastery now.
Sure.
Okay.
No, I understand.
I mean, I don't want to sound unfriendly, or
No.
we get along.
Everybody start throwing chairs. It's all right. I get it. Okay, so annual meetings are important. I'll go ahead and mention this too, because you hear this a lot, and I think this is because we elect presidents, we elect to an office politically, but for the corporate world it's different. We typically elect to the position, board position. And so the sky's not falling when I find an association and they call me to a meeting and I go and they're holding an election for a president, vice president, treasurer, secretary, and I look at their bylaws and it says nothing about electing officers, it elects directors. Technically, that you're not following your bylaws, but let's not make a big deal about that. Let's conform it going forward and correct it when we can. I understand that, and I don't want to make light of living within a community association. Obviously, I built my practice around serving associations and individuals that live in them. But there is a tendency sometimes for people to ramp up the seriousness unnecessarily. And that's one of those things that you'll find. You get people getting really bent out of shape because dues are going up or they didn't get their vote. And so now they're going to make records requests and demands on the board. They're going to run you ragged. And they're going to nitpick and all of this stuff, which is their right. That's, you have a right as a member to the books and records of the association. But to a certain point, I mean, this is a volunteer board, and that's partly what I'm trying to do with some of these things that we're talking about, is you can remove a lot of those arguments, remove a lot of those pressure points that people seem to use, and that's having annual meetings. Another one is giving notice, following your covenants or your bylaws. If your bylaws provide no less than 10, no greater than 30 days notice, well then follow it. And if you don't like it, then we can change the language in the covenants or in the bylaws. But until that's changed, just follow it. Now you've taken that argument that somebody's going to beat you over the head with, well, you only gave me 9 days notice. Yeah, you're right. So what? But you can't really say that. I know for some folks at different times in their lives, well, let me ask this. Raise your hand if you have a problem getting people to your corporate meetings, to your association meetings. Yeah. It's a problem. And if you're getting 20%, 30% at your annual meeting, you're doing great.
We're doing great.
It's usually, well, that's good to hear. Because it's usually around 10%, 15% is what shows up at your annual meeting. Well, for some people, it's apathy. For most people, it's apathy. For some people, it's childcare. I mean, you've been in church, you've been in Walmart, you've been in those places where the kid's going crazy, and most people are giving the parent, the stink eye, because it's like, why can't you control your kid? Well, every parent's been there at some point, and I've been there, and I've got perfect children. So having childcare, and I'm being facetious, of course. Having childcare, providing refreshments, building the annual meeting around something fun, good ideas. And then using proxies. Proxy, and I've got a slide on it in a second, but a proxy is simply a piece of paper that gives an individual the ability to show up in person, somebody else to show up in person so that I don't have to, right? And that's a really good way to get your quorum.
I have a question on proxies.
Yes, sir.
Should they be notarized?
No, do not have to be notarized. Nope, they can be faxed, they can be emails, a text message could serve as a proxy. Now, I'm assuming that we don't have specific language in our bylaws. If there's a bylaw that says proxies shall be notarized and provided to the secretary prior to the date of the meeting, we've got really specific proxy language, and you should amend that or follow it. Board meetings. No, the Open Meeting Act and the Open Records Act does not apply to homeowners associations. That is, those are sunshine laws for government. They're not designed for private corporations. So when that owner who is cinching up the seriousness and starts sending you emails that you're not in compliance with the Open Meeting Act, thank you for your concern, but we're not subject to the Open Meeting Act. Occasionally I'll get the question, should we amend our bylaws to make the Open Meeting Act apply? Only if you like criminal liability, because that's what the Open Meeting Act does. We want to hold our politicians to a level that probably our non-compensated volunteer board members shouldn't be held to, and that's what the Open Meeting Act would do. We don't need the open yes, sir.
Oh, sorry, does that just imply that if you have a board meeting that minutes or something like that don't need to be posted necessarily?
No, that's different. It means that, well, the Open Meeting Act has very specific particulars on notice, what has to happen out in the open, who has access to the meeting. And so, for example, in Oklahoma, there's nothing that says individual members have to be given access to board meetings, right? Sometimes your bylaws will provide that, and if your bylaws provide it, then you do. But again, what I see a lot of times is this cinching up of either limitations, limited access, limited information, either because of defensiveness or because I just don't like this person and I don't want to, I don't want to deal with them, or maybe alternatively, I want to put the screws to them. And so sometimes there are instances where we need to limit member access, but for the most part, we're dealing with $100,000 or less budgets. I know there are association budgets that are much higher than that, but for the most part, we're not dealing with a significant amount of cash. And so what's the harm in having the individual member there?
By board meetings, do you mean closed meetings of the officers? What do you mean by board meeting?
The group that operates the corporation.
Okay.
It's the board, the officers, the president, secretary.
So it's perfectly okay to have a closed board meeting?
It is.
That doesn't include the other residents?
It is okay. Now, when it becomes not okay is when that closed board meeting creates an environment of suspicion. This is a fraction of the owners that are in this smoky back room making all these big decisions. We can cut that kind of talk out by saying, you want to come be board in our meetings? Go for it. Join us.
A board meeting is really probably all these big neighborhoods. I mean, like we have annual meetings, but everybody comes and that's where everything's taken care of.
For neighborhoods
About why we'd have a board meeting.
Well, for neighborhoods your size, and it may be depending on the covenants and the requirements, y'all are more of a congregational style where everybody shows up and
everybody knows each other.
It may be that you wouldn't have board meetings and annual meetings per se.
Okay.
So then, am I right in that meetings and practices like this are really best dictated and followed by following the bylaws?
Yes.
Of the corporation?
That's correct.
That's the governing
That's right on target. The bylaws are going to govern this and answer these questions. Now, sometimes the board does need to go into a closed session. Those are called executive sessions. So if I meet with the board, one of the first things I'm going to do is close all the doors and make sure that everybody in the room is a board member, because I don't want attorney-client privilege being breached or confidentiality breached, and I want to make sure that if this is something that doesn't need to leave the room, so for example, are we going to sue this individual for an alleged covenant violation, and the ins and outs of that? What are the strengths of the case? What are the weaknesses of the case? And having a conversation with the board. Now, you understand, despite the fact that you're next door neighbors and y'all have coffee or play golf, you can't share this information. I mean, those conversations need to be held in a different environment than an open board meeting. That's called executive session, and that would be appropriate to close that off. Yes, sir.
If you have a long-standing set of covenants, but you've never been incorporated, do you just move the covenants and incorporate and call those bylaws, or do you need to rewrite those covenants in some sort of way or fashion?
Yeah, so
Bylaws.
So say, for example, let's go back to our scenario over here. Developer develops, sells all of the lots, files covenants, and we don't have an incorporation, but the covenants create a homeowners association. So we're going along, 20 years goes by, you go to a seminar and the lawyer says, absolutely, don't operate without a corporation. And so now, first thing you're going to do is you're going to go get incorporated. Has nothing to do with the covenants. Although, like I said earlier, if the covenants define the association name, be sure that you incorporate that name. And then, under Oklahoma law, either the first board or the members, the general membership, can adopt bylaws. Now, there should be some language in the certificate or the articles of incorporation that answer this as well. Sometimes they're silent. But under Oklahoma law, and this is Title 18, Section 1013, if you want to go on OSCN and look it up, what that says is that the board, it uses the term governing body, and if you pick around in the General Corporation Act, you'll find that the term governing body refers to the board. They can adopt bylaws. And so if you find yourself in this situation, particularly in a large neighborhood, it would be impossible to get a majority vote, or very difficult, and it doesn't make a whole lot of sense to put in a good set of bylaws when you can just do it with the board. So that's typically what we'll do. You'll incorporate, get the name right, the board will adopt bylaws, and then send them out to the membership and say, we're now incorporated, here are our bylaws.
So again, when you're saying adopt bylaws, would that require a rewrite of those covenants, or part of them, or is it two totally separate documents? Two totally separate documents.
Now, what we don't want is conflict between the bylaws and the covenants, and we can't, and all of this stuff has been fully litigated over the past 20, 30 years, not in Oklahoma, but every which way of, okay, well, amending covenants is difficult, adopting bylaws is easy, so we're going to skip amending the covenants and we'll just do in the bylaws what otherwise would do in the covenants. That doesn't work. So for example, leasing.
So on a board meeting, how is there continuity at the actual meeting? Do they go under Robert's rules of order, or do they establish another rule of communication between the board members? Who can make this amendment? How many have to second it? How many have to? Is all that? I mean, is it simpler to be a Robert's Rule order?
I wouldn't say it's simpler, but the answer to the question is it really just depends. It depends on what the bylaws require. I can tell you what I find most is, even if the bylaws do require Robert's Rules of Order, you find something less, something what do you call it? It's almost like a pigeon language where you've got the customs, the way people have done it. So for example, you get to the end of a meeting and correct me if I'm wrong. I keep looking at him when we talk about Robert's Rules of Order because Craig's a registered parliamentarian. He's one of the, if not the state's guru on parliamentary procedure. And so for example, you get to the end of a meeting and somebody says, "I move we adjourn," and you get a second. Well, as I understand it, you don't have to do that, right? And so people use Robert's Rules of Order like they
like a weapon.
Well, like a weapon, or like they think they know what they're doing, and so usually what you find is this mishmash.
Can I take about 30 seconds?
Absolutely, yeah.
One thing that Robert allows in the manual is you can create any rule that you want and run by it. Robert is, if there is no rule, here is your parliamentary authority that's your backstop. It's where you fall back to. If you want to do anything different in Robert, you just create a rule, pass it, and it's the rule.
And that's usually what you find is you do what's functional, what works, and if somebody starts to get unruly, then you adopt a rule that, all right, we're going to limit comments, 1, to non-profanity, 2, to 2 minutes at a time. Most of the time, and y'all experienced this, most of the time people operate within a certain level of decorum. Occasionally people just have that thing that's lacking in them, and we have to get them back in the bounds, and we can do that with rules. But really, again, these meetings, we want to use agendas, we want to keep them on track, we want to keep them to an hour, 2 hours, because if you don't, you're going to burn out your board members' batteries, and there's not a whole lot of people clamoring to serve on these boards anyways, as you probably well know.
I have a quick question. If we're that little HOA that's not incorporated, and we're handed covenants and bylaws, who created those bylaws?
I would guess the board.
We were the first board.
Probably your developer. Your developer.
So once we become incorporated, can we write all new bylaws?
Sure.
It would have to be voted on then by your new board and then presented to your neighborhood.
Before it could be official?
We'll go into depth about amendments, and primarily covenant amendments, but also bylaw amendments. And there's some considerations there. Even though I just told you 18 OS 1013 allows the board to unilaterally or by themselves adopt bylaws, that may be the worst political decision the board could make. And so we'll talk a little bit about strategy and planning. Last thing I want to mention, think in terms of where your annual meeting is held. I used to be able to say people don't cuss at churches when you're having an HOA meeting. Well, I can't do that anymore. But for the most part, people will be on better behavior when they're sitting in those little bitty cafeteria chairs in like elementary schools or elementary libraries. And usually people will respect the environment that they're in if you're in a church sanctuary or chapel or something like that. So think about that. If you're going to have a very contentious meeting, then I have found that those things work fairly well. Yes, sir.
But specific to the board meetings, are you recommending when they're called to notify the neighborhood you're having that board meeting?
If it's open, yes. Definitely if it's open. That way they have a meaningful opportunity to show up. If it's not open, I still think it's a good idea to keep the membership up to date, keep them involved. If you can provide them a copy of your agenda, this is what we're talking about, but no, you're not invited. I still think that's a good idea. That way, where you see people start to get a little antsy is when they don't have access to the financials and they don't have access to the board. There's this idea of, all right, what am I paying for? What are you guys doing? What are you doing with the money? And that's when people start making records requests and getting a little antsy.
Are you going to talk about covenants amendments later on?
Yes. Yep. Yes, ma'am.
Can I ask a question about elections?
Sure.
Or is it something like that?
No, go for it.
We work for a management company, so we have almost 30 associations that we manage. We have a couple that we cannot get volunteers. So there is no board. So we, at one point, it got handed down to a management company, and then our company purchased it, and there's never been a board to report to. So we do our best to send out financials and be as transparent as possible to the membership, but we can't get anybody to volunteer to be on the board. Do you have any suggestions on what we should do?
The answer to your question is yes.
What's crazy is this association has a good chunk of money,
And you get paid.
and we get paid, but, when we first started, we were sending out financial packets each month to somebody 6 months later down the line. They said, "I'm not really sure why you're sending this to us," and we were told that they were the ones that were overseeing it.
So who hired you?
Well, we purchased a management company, and there was a death. So it was a weird situation. So, and we've gone back to the previous developer, and nobody can really tell us, nobody's really all that interested in it. But we've held a meeting. I think we had 3 households show up.
How large is the neighborhood?
There's 100 and... Financial Johnny, they've got over $50,000 sitting in the bank. Now, there's not a lot that they can do with it because there's not a lot of common space, but we tried to, the 3 people that showed up, we tried to give them some ideas of, community type things to do, but we can't get anyone to volunteer.
Knock on doors and make sure they're still alive.
Yeah.
Well, yeah, they're still alive, but.
Yeah, I think from a management company standpoint, it's a different consideration. And so I'll try to answer it. If you're a board and you find yourself in the situation where you don't have people volunteering, and because sometimes what you hear is, well, if there's no board, then there's no association. It's defunct, it's gone. I had the question the other day about, well, what does it take to resurrect the association? And I like a ship analogy. You can sink a ship, but just because all the crew and passengers jump off the ship doesn't mean we can pretend the ship doesn't exist. And that's the way it is with an association. You still have the ship, it's just now a ghost ship and, floating around and bumping into stuff. You can get rid of an association, but you cannot get rid of it by ignoring it. You have to kill it. And if you're in Oklahoma County, Tulsa County, surrounding counties, the municipality is not going to allow you to kill it. So you're stuck with it. And so I'll answer your question. What you have to do is, 1, think about liability. 2, community building exercises. I would get with Georgie and Ashley Neighborhood Alliance and figure out.
I'm not giving up,
But I'd be asking myself the question, what authority do I have to pay this vendor over that vendor, or pay myself, and at least.
So, in that situation, what would we do to absolve ourselves of the duties of it?
You don't have a contract with them. You cancel your contract, terminate your contract. It's like any other vendor. If I don't want to do business, it's like if y'all want to fire me as your lawyer, you tell me you're no longer my lawyer, and we're done.
But doesn't somebody take it over if you don't have an association?
do you mean take it over?
That's the question. I mean, there's a bank account sitting there. I wouldn't know what to do with, I mean, I guess I'll just leave that in the hands of the bank, I guess. Okay.
Yeah, that's my question. So if you're not a management company, but you're an HOA, and nobody wants to serve on the board, and nobody wants to do the financial work and everything, you must kill it, which you said you can't kill it, and it's also kind of...
So at that point, everybody is bobbing in the water, staring at the ship.
And you have a life jacket.
And you wait until someone says, well, this is stupid, I'm going to climb back in the ship and steer it somewhere.
When the gas gets about that high.
So then, let's say you have 165 lots in your HOA, okay, and this happens, do each individual lot owner only have 1/165th of the total liability?
Oh, that's a good question. No. No, not from my standpoint if I'm the creditor. If I represent the creditor, and you're assuming that they're unincorporated, because
No, they're incorporated.
if they're incorporated, then the corporation continues. Still,
It's like a human being. Okay. Corporation continues, but
there might be arguments that I can, what's called pierce the corporate veil, meaning I can walk right through the corporation and go after the individuals. That's a real unique set of circumstances, but assuming that we could do that, then I would argue you don't have 1/600th or 1/160th of liability. You have 100% that I can collect from you, and say I only can collect 1/10 of it. Then I can look at the next richest guy or gal. Yeah. That's called joint and several liability.
joint and several.
And it sucks.
That's a unique situation that goes through the veil.
Legal term.
That's not too
What's that?
Well, for instance,
Piercing the corporate veil it's a very unusual situation. That's why I was saying, yeah, that's an exceptional set of facts.
we have $1 million liability also, insurance for the association.
Yeah. Well, let's go ahead and get to that. I know I've got some of those slides coming up. Let's talk a little bit about insurance and layering of protections. So if you're a new board member hearing the conversation up to this point, you're thinking, well, I know I haven't gotten a paycheck and we seem to be talking about personal liability a lot. Why in the world would I continue to do this? And there are really good protections for board members. One is incorporation. That's the easiest, and that's why we keep talking about it, incorporation. And then another one is insurance. And just suffice to say, asking the question, we'll get into more detail next week, your association can own an insurance policy, and the type of insurance policy, in addition to property and liability, property being tornado comes, destroys something that the association owns, will the insurance company replace it? That's property. Then there's liability. If someone gets hurt on property that the association is responsible for, private road, common area pool, that kind of stuff, that's covered by liability. And then there's a particular form of insurance called directors and officers, commonly known as D&O. Might be known as E&O, errors and omissions, but oftentimes it's a D&O. And that's the insurance policy that the association board wants to place. That's going to typically protect the board from claims of breach of fiduciary duty. Those policies will typically have an employee dishonesty provision, which covers in the event of theft. You don't have employees. Don't think of it in terms of, well, we don't have employees, we don't need it. It would be if the treasurer absconds with $100,000 of your reserve fund, employee dishonesty will cover that. The main thing that we're looking for with the D&O policy is if a disgruntled owner actually files a lawsuit against the board, which honestly is pretty rare. It's not a common occurrence. then the directors and officers policy should provide an attorney, and that's really what eats you alive. It's not personal liability and a judgment getting hit against individual board members or even the association. It's the attorney's fees to get to the conclusion. It's very expensive. Yes, sir.
Do you have recommendations as far as the amount?
No. No recommendations on amount. I recommend if your governing documents specify an amount, that you place that, and then the board seek professional advice, an insurance broker, on what would be an appropriate amount for your development, for your neighborhood.
Do you have any recommended insurance companies or anything?
No recommendations, no. But I can tell you, I have seen a number of insurance companies that place policies for associations, but I'm giving absolutely no recommendation, fitness of purpose, all of that stuff. Bruce Chaddock is a broker. He's with Ledbetter. I know he does a lot of condo policies, homeowners association policies. State Farm places a lot of homeowner association and condo policies. Firemen's. Sometimes you'll get a developer's policy that's a holdover, which would be like mid-continent. What I would recommend is you find an insurance broker that's not tied to a particular company that can shop different and see what's available.
These fancy neighborhoods that have pools and clubhouses and stuff like that. I mean, everybody just, our place is 4 acres and we mow a lot.
Do you have a private road or is it a public road?
No, it is a private road. But why would what instance would someone sue if they were on a private road?
I'm visiting my mom that lives in your neighborhood. This is a hypothetical.
Right.
Visiting my mom that lives in your neighborhood. I've had a couple of drinks at mom's house. As I'm leaving, I hit that huge pothole that's on your private road that y'all have been intending to fix. You just haven't gotten to it yet. There's no cones, or maybe there are cones, I just didn't see them. And hit it, and I'm damaged in my person, or my car is damaged. I'm going after the person who's responsible for maintaining that road, and that's your association. That's how that happens.
An oddball, but they happen.
It is an oddball. It doesn't happen very often, but association leaves its sprinkler system on, and it ices over in an area that I wouldn't expect it. It's kind of dark. I can't see it, and now I've got to slip and fall.
But if someone's on a city street and that little scenario happened, they don't sue the city, do they?
On a pothole? Absolutely they can. If it's been turned in, they can.
Okay.
Yeah, I think the county, of course, that falls under what's called the Government Tort Claims Act, and it's limited to a certain amount, and you've got to jump through some hoops.
Good to know.
About 80% of the roads here is 100.
Come on.
Yeah. Okay, so we limit liability with corporations. We talked about insurance, and there's one other thing that I'll tell you for you just to write down on your checklist, and that's, has your association filed a federal income tax return? And you want to file, it's a Form 1120H. By the way, we're over an hour now, and I didn't tell you all this. I just keep talking, and I don't take a break. If you need to take a break, get up, mill around, stretch your legs, go to the restroom, that's perfectly fine, but we'll go right up until 8 o'clock. So 1120H, that's a federal form. If you Google 1120H, you'll get the instructions, you'll get the document. You're not filing this because your association fears the IRS is about to do an audit. I've never heard, and as soon as I say that, it's going to happen, but I've never heard of the IRS auditing an Oklahoma run-of-the-mill homeowners association, right? There's no reason to. And it's not because you're going to owe taxes. You might owe a little bit of taxes if you've got a huge reserve fund, $100,000 that's earning over $100 a year in interest income. Then you might pay taxes. The reason you file that is because under Oklahoma law, and I'm going to flip back. Under Oklahoma law, 18 OS 865, 866, and 867, you can go read those, but what they do is they limit joint and several liability, they get rid of it. So what it means is if we're serving on a board together, I'm not going to be responsible for your bad acts, you're not going to be responsible for my bad acts. It's individual responsibility, okay? No joint and several liability. This set of statutes also ramps up the standard of liability. And what I'm talking about is you've got simple negligence or regular negligence, and you've got things called gross negligence. Simple negligence is we're all leaving here, you're backing out to leave, and you hit me with your car, right? It's the typical car accident, some kind of tort claim. It's not an intentional act. Hopefully you're not trying to hit me with your car. It's what we call an accident. That's simple negligence. Gross negligence would be something that's outrageous. Grossly negligent would be I'm driving along and I shoot a gun into this room and I know there's people in here. It's reckless, it's a disregard of human life or people's rights. It's outrageous conduct. That's a higher level of negligence. So what this set of statutes does is it ramps up board member negligence to gross negligence. So how does this work? It keeps individual board members from having to fend off armchair second guessers. Y'all shouldn't have spent that much on the roof replacement. Why did you hire that painting crew? The common area clubhouse looks terrible. It's people that just want to whine and complain, and then it also covers people who might want to bring a claim that you made the wrong decision. You were negligent. You should have done this. If you file an 1120H on an annual basis, these statutes apply, then those simple negligence claims, the board has immunity. It's a really good set of statutes. Yes?
If they haven't been filed in the last couple of years.
File them. Yep. Go back and file to get you up to speed.
Can an individual lot owner look up the 1120H of their association?
I don't know the answer to that.
Okay.
I don't know how the IRS. So I'll answer that two ways. If the individual lot owner is asking the IRS, I have no idea. I don't know what they would do with that. If they're asking their individual board, the board should make a copy and send it to that individual.
They should. They're not compelled.
Not yet. But I can tell you, not yet, because if I haven't met a judge yet who looks fondly on boards that withhold information from individual members. Now, when an individual member asks for a copy of the attorney invoices, the emails to the board appropriately says, no, we're not giving that to you. When an individual member says, I want to see the bank statements along with the canceled check pages, board needs to provide it. Now, they don't have to jump and provide it immediately, but that is a book and record of the association. I have boards that refuse to provide them. I had one in Canadian County refuse to provide it based on privilege, that it's a financial privacy deal. So walk me through, how does the financial privacy attach to the checks that you write and give to a third party? I mean, it was an asinine argument. They just didn't like my client, didn't want to hand over the documents. That's the stuff that gets people very angry with their association boards and gets the board sued. when they're taking positions like that.
Are you going to go into fiduciary responsibility and duty later on?
Next week. Yep. Yes, sir.
Just have one question on the, what if you have a board that says they filed the 1120Hs and they never really have filed those?
Well, you mean what happens?
And how does that apply to the board? I mean, does that do anything other, I mean, you said something about liability involved.
Other than, them being liars? I can't think of a compelling reason why you would lie about that, but I guess.
Because they don't want to do it. I know, it's silly. But
Yeah.
would that be any reason to take them to say, either that or we're going to go forward or we're going to...
It would be reason to take them to a doctor. I mean, it doesn't make sense that someone would know to do that and then willfully choose not to. I mean, that is a board member that needs to be not a board member and get someone in that can make a decision.
But they're elected constantly, been elected for 20 years.
Yeah, they've served their term. We need to move them along.
Serve a different term.
But I think the crux of your question is there a lawsuit or is there financially?
What do you do? How do you force them to do it? I mean, what the people of the HOA, what do they need to do to tell the board this needs to be done? So how do just let it to the board?
Yeah, make a demand, start a paper trail, provide me a copy of the 1120H. What comes back from the board is there are no copies of the 1120H because we don't file them. Why don't you file them? There's really good reasons. I mean, this is like taking a breath when you wake up in the morning as opposed to I'm not going to take a breath when I wake up in the morning. I mean, one is so much better than the alternative. There's no reason to choose the alternative. And I would make them put that in writing, what their reasoning is. I mean, it may be, that is such a weird, decision to make. I've got to think that they've been told something that they think something weird or that it's an education issue. If they truly know we're supposed to do this, but we're refusing to do it, they need to be removed as board members. That's wild. I think if you had gone through each of those steps and you had a board that you could not get to file it, the result is you remove those board members. I wouldn't find that as a discretionary matter. I mean, filing the tax return, it's kind of like incorporating. There's no good reason not to do it. Is there another question? Yes, sir.
On the 1120Hs, if you go back and file from 1-2 years ago, is there any sort of penalty?
I can't answer that question. You probably want to talk to a CPA. I think that's the right answer, but I can't give tax advice, so.
Is that the only form you file? Or are there any other forms?
You'll want to talk to an accountant or CPA and ask about a Oklahoma form. There is not an Oklahoma corollary to the 1120H, and the statute, Title 18, Section 865, is tied to that 1120H. It's not tied to the filing of any Oklahoma form. But I do know that there are associations that file an Oklahoma form.
If you have somebody that does your taxes for you, would they automatically do that?
Should.
Okay.
Yeah. Yeah, if they're doing your taxes and they don't do this, I would, kind of like our board member, I would find another tax professional.
Exactly.
All right, let me pick up back where I'm not cutting off the topics of conversation that we've covered. I'm just moving on because I want to hit some high points again, and we're about 3/4 of our time in. Yes, sir.
I have a quick question.
Yes.
Can a developer HOA amend the CC&Rs after you moved in? I think I know the answer, but I don't.
The answer is, if I drafted the covenants, an absolute yes, they can. We call if I drafted the covenants. If they use me as their attorney, then when that developer hires me and they file the plat, we immediately file a set of covenants before any lots are sold, because we have 100% of the decision-making authority, right? My developer.
What happens if it's not done before any lots are sold? The CC&Rs aren't filed.
That is malpractice if I do it. It's a bad day for the developer if they do it. I make sure that I don't do that. That is a really big deal. And what he's talking about is this lot gets sold to individual, and then the covenants are filed. So if this is a timeline, so this is day 1, this is day 2, this is day 3. And we're talking about filing in the real property records. So the plat gets filed with the county clerk on day 1. That's what creates the lots that we can refer to as Lot 1, Block 1, Happy Acres Edition. Now developer can transfer a deed, transfer title, and if they sell this lot and then they file the CCRs, well, they've done it without the approval of this lot owner. You have to have, and I'm going to modify this in a second, but you have to have 100% at the outset in order to have valid covenants. Okay? Now they probably have valid covenants against all of these other lots, but we've got one individual that the developer let loose. So that's one issue, and that may be the issue you're talking about. We usually mitigate against this. I make it abundantly clear to my developer clients, you cannot let this happen. This is a big problem. It's not so big of a problem if we have a private road. So, for example, if this is, say this is a private road community, it would have to be like this, wouldn't it? If this is a private road, this individual is going to have a hard time saying, well, I'm not subject to any covenants. I get, free access to my property over this private road. It usually doesn't shake out like that. You don't get a free ride. And so usually we can get that person back in after a little bit of discussion. But if it's public roads and there's no plat that says common area shall be maintained by the property owner association and is comprised of the lot owners, if we don't have that language, this one might be free and clear. Okay, so that's an issue that we have to watch.
Say that again, please.
Remember on our plat, we had that plat restriction. So if we have that plat restriction, the plat's filed before this individual took title, they can't claim they're not a member of an association.
Oh, okay.
Now they might be able to claim, I don't have to build a 2,500 square foot house because that's in language after I took title. But they would be subject to all the plat restrictions.
So if the developer says, like some 50 lots of 165 are sold, and then the developer comes in and makes an amendment that says that no person under the age of 25 who can, under the age of 25 can be a guest of a resident for more than 60 days in any one calendar year. And it's an active 55 plus community. And I asked the attorney, representing the HOA, is this in accordance with the standards of the federal law that gives them certain tax benefits, or is it more stringent? After the third ask, he finally said it is more stringent. Now, this happened like 2-3 years after I owned the lot, and the developer still had 100% control. And what I'm asking is that legal?
There's two answers to that, okay? So the first answer is forget this hypothetical. The question is, we've got plat filed, covenants filed, all of the lots are sold, we're down here, can developer...
Not all of them are sold.
All right, some of the lots are sold.
Right.
Can developer unilaterally amend the covenants? And the answer is, it depends on what the covenants say. And this gets back to my comment. If they used me as their attorney, the answer is yes, because we put language in there that says, unequivocally, developer can unilaterally, without approval of anyone, for so long as developer owns one lot, and even a time period after that, can unilaterally amend the covenants. I want that in there. So when FHA or VA comes along and says, hey, we're going to change our underwriting guidelines now, we're only going to issue loans if your covenants say this, which they did for condos several years ago. I don't want my developer to have to go back in the neighborhood and get a vote, because you're going to get people who are apathetic or just vote no. All those cash customers, well, people shouldn't use credit anyway, I'm not voting for it. I don't want to have to go to their door and have to convince them, look, don't shoot yourself in the foot here just because you don't use credit. So I want the king, we call it the King's Clause or the Queen's Clause, depending on the gender of our developer. Because there's really good reasons to allow the developer to come in and amend. Now what happens when developer, and I know a lot of you are thinking, nah, I don't like that. I don't like the fact that the developer has that much power and authority. But what happens when a developer uses that power and authority in a way that chaps off the 50 people that are living there? That's when the signs come out in the yard. That's when the neighborhood is in an uproar. Well, what kind of environment is that for a developer to sell their remaining lots?
Well, but
it's horrible.
It's also said in the CC&Rs you can't put any signs up. And you can't fly the American flag, which I learned about that.
Well, if you have a developer that's filing covenants that says you cannot fly the American flag, I would say there's probably a judge in Tulsa County that would be receptive to that association or those individual owners. And so the quick answer to your question, and that's one that I would love to litigate. I'd love to litigate a daycare case, and I would love to litigate a sign in the yard case, just in case anybody's got those, because they're fascinating. It's almost like what you were talking about. You've got this and to a guy like, this is the geeky stuff that HOA lawyers think about and gets them excited. So you've got this layering of these very important rights. The freedom to behave religiously the way I want to or choose to. And then you've got these layering of property rights. You've got freedom of speech. Now, the association is not a government actor such that the First Amendment applies. So the quick answer is, well, of course the developer can limit signs because it's not a free speech issue. It's a property rights issue. Are you telling me, well, like the flag, there could be a right legal answer and you lose the case. That's the flag case. The association could be right that, well, yeah, we have the right to restrict flagpoles, which the flag's attached to a flagpole, but you're going to lose that case.
Who's going to lose it?
The association trying to restrict flagpoles. So with this one, the answer to the question is the developer should have the right to amend, could have. The rest of your question, if I understood it correctly, You're talking about a HOPA community, Housing for Older Persons Act, and basically that's a legislated discrimination that our Congress put into place because, and I say legislated discrimination, not to get people riled up, but that's because absent that statute, absent Congress saying you can create communities and we are going to limit the age of people that live in there. Because if you limit the age outside of that protection, it's discrimination.
Right, but only 80% of the lot owners must be 55 or older.
There's a corridor that you have to fit into.
But what you're basically saying to me is read the CC&Rs very carefully and see if it says in there that the developer has a right to amend however he wants, whenever he wants.
Yeah, it better say that. Otherwise, that amendment's invalid.
Right, okay.
Yeah.
How would you get the paperwork of what that property owner, the one that started it, that you know of the language that is written of about the people that can live there? Well, let's say it's an assisted living a deal, and there's older people living there, but like sometimes there's 4 or 5 kids there too, that are not part of that agreement of what their age, assisted living requirements are.
All of that language, that HOPA, it's called a HOPA amendment, Housing for Older Persons Act, HOPA for short, it's going to be filed of record. It's going to be filed just like the covenants are.
Where would you go to get that?
The county clerk's office, same place where you file deeds, mortgages. It's the county clerk. So what town is your neighborhood in?
Oklahoma City.
Okay, so Oklahoma County, you go down to the second floor of the county admin building, down there off Robert S. Kerr, and actually you don't even have to go down there. You could go to oklahomacounty.org and look at all of those documents online. Now they're going to have a watermark that says not official, that it's the same document. All right.
oklahomacounty.org.
All right. I don't want to run out of time. We're not going to, but I want to show you my favorite slide. So, one of the questions, actually we've talked a little bit about it. Why would we amend covenants? If I'm a developer, I'm going to amend covenants sometimes because there's a change in the law. So for example, back in the 60s, 70s, 80s, on up until 1996, satellite dishes were fairly unregulated, and they were the big ones, And then in 1996, Congress passed the Telecommunications Act of 1996 and said that associations, property owners could restrict the size of satellite dishes that were over a meter, which is 39 inches. I think it's about 39 inches. And so now we had all of this covenant language that says something like, no satellite dishes shall be visible to the adjoining property. Standard language. Well, as soon as that act was adopted, that language is invalid. It's unenforceable. It can't be that no satellite dish can be visible because the Telecommunications Act says if it's 39 inches, you can't pretty much tell me anything, with some exceptions. If we're in a condominium, there are definitely exceptions. But so all of those visibility requirements shall be the same, painted the same color as the house, shall be located to the back of the lot, which doesn't work if I have the front faces, has a southern exposure because we got to have our satellite dishes facing south. All of those covenants are no longer workable. And so that might be a reason why we would go in and change these. Okay. Or we could have language, this is my favorite slide. So just read this, let it soak in.
No discrimination there. That's called the Telecommunications Act of 1996.
Yes, and actually, if you Google, or if you go to the FTC website, if you have any question, anything dealing with satellite dishes, the FTC website is fantastic. They've got memos, they've got the law, they've got the cases that have been litigated. Really good information. If it's not my favorite government website, it's one of them.
Let me ask you a question. I previously lived in another association that was very inactive, but everybody was very calm and cool. And I live in another one that the developer says, oh, it's got to be this way. You got to have wood mulch. Well, 2 houses now have stone mulch. Okay, there's no windows allowed in the garage doors. We have at least 4 houses that have windows in the garage doors. All garage doors must be wooden. We have at least 4 houses with aluminum garage doors and 1 with steel garage doors. Is there any length of time or number of covenants that run in violation of the then issued covenants that nulls and voids those covenants or all of them?
I'm going to answer the question in terms of amending the covenants, because that group of issues and the answer that you really want is next week.
Okay. That's all right.
So one of the fixes, though, one of the answers is, so you've got all of these covenant violations. Well, maybe it's because the covenants didn't match the neighborhood to begin with. And sometimes you have associations that the conversation is, well, we've got to enforce the covenants. We've got to enforce the covenants. And maybe the conversation needs to be, well, what's the point of this covenant? I'm certainly not saying what is the point of covenants. That certainly isn't the idea. But if we have a covenant that says no blue houses, do we want to spend attorney's fees on no blue houses, or do we want to ask the question, what's wrong with blue houses? If we want to have home-based businesses, then maybe the covenant language should conform to that. If you don't want home-based businesses, if you don't want Airbnb in your neighborhood, then maybe the covenants should reflect that. And so that's the amendment answer. Maybe we need to amend to conform to the actual development or the actual uses that we want to make. When we're talking about enforcement, we'll spend a long time next week on that, because it's a complicated analysis.
Also, that the developer seems to think that he can allow certain violations. Will we talk about that next week?
Yeah, bring that up again next week. So,
he ain't, let me tell you.
Can anybody guess what this is talking about? That hasn't seen the slide before. Don't cheat. Craig didn't answer.
You got a big lake in the middle of your neighborhood, and people don't shoot straight anymore.
Ski Island, yeah, they don't allow that.
That's right. They don't in Ski Island. This isn't Ski Island, though.
Only when you're skiing, man.
But kind of the same kind of development. Ski Island's built around a lake, and where this comes from is the same. And this is. Does anybody know what this is talking about? Did anybody guess it?
If you're handicapped, you can still shoot from a boat.
That's one interpretation. That's a reasonable interpretation. But can the boat be moving forward? Can it have a motor? If it doesn't have a motor, can it be moving forward and me shoot?
So you got to shoot from the land.
This is talking about duck hunting.
Yeah, but it doesn't say you can't shoot from land.
No, it says not. It's talking about shooting from boats, but then it's also not clear on can you shoot from a boat as long as it doesn't have a motor? Take the motor off my boat. Does this apply to me?
Well, I thought it was saying no shooting except shooting cripples.
Yeah, or is this the most horribly, un-PC? Yeah. That's right. So this is the best example I've come across of sometimes you get saddled with really bad covenant language, right? And it necessitates, I mean, even to just get meaning out of it, we've got to change it. We've got to amend, right? And so I'll give you a couple more reasons. Sometimes there's, that language is what I would call defective. Sometimes it's obsolete. So there's a life cycle in a development. We have our illustration here. So developer wants to get to the finish line and sell all of the lots. Most developers are done with the development. Sometimes you'll have a developer that builds themselves a house and they stay in the development. But apart from that, they're done once they've handed over the association and sold out all their lots. Well, the covenants aren't necessarily drafted for, I'm going to say, y'all's benefit. They are to a certain extent, but there's a lot of language in there that only benefits the developer. One of the terms that you might find, there's going to be Class B control period or Class B member, which is just the developer. There might be some annexation or addition language. There should be in the covenants if this is a phased development. What that says is developer retains the right to add, I left my marker over there.
There's one on the floor.
Okay. So for example, if this is Plat 1 and developer owns this land over here, it may be that we file Plat 2 and I want it to be part of this neighborhood. Well, that doesn't just magically happen, despite some developers' beliefs. Well, if I own this land, why can't I just stick it with that land? Well, because you've got to reserve the right to do it. You've got to tell people this is the plan. You can't just wake up and say, hey, guess what? You've got more members. So that's language that's going to be in your filed covenants. And after all of the phases are done, developer moves on to their next one. That language is still in your covenants. You may want to clear all of that out. Yes, sir.
That's what we're dealing with in ours. We haven't formally started our HOA yet, but we have phase 1 and we have phase 2. There's actually 2 separate sets of CCRs. One for phase 1, one for phase 2. There was originally going to be a phase 3. He has since sold that. And is no longer going through with that. So we're at phase 1 and phase 2. CCRs for phase 1 actually has a set of bylaws.
Okay.
Phase 2 does not.
Does phase 2, so let's talk about this a little bit too. So sometimes in a developer style or the way that they're structuring the development, you'll have, with Plat 1, you'll file CCRs, and then when it comes time for Plat 2, and I know this is getting a little small, but we'll file what's called a supplemental declaration.
Okay.
Basically, a supplemental declaration says, hey world, remember the covenants that we filed for this plat? We're doing the same thing for this one without restating everything. It's how we normally do it these days.
This one's not.
So there's another way to do it, and it's not. I can't say it's wrong. It's just a little more meaty, I guess. So this way, you've got CCRs for the first plat. You've got CCRs for the second plat, and they might be from the same form.
They're real close, but there are small differences.
And it's
with the first one, he did actually establish a corporation, an association. Cedar Creek Homeowners Association Incorporated. That is actually filed with the state.
Okay.
On the second one, it is Cedar Creek Phase 2 Homeowners Association Incorporated.
Okay.
Not filed with the state.
Okay. So what that does is, and this is what you're looking for when you see this kind of development structure. You're wanting to see that it's not impermissible to have two sets of covenants, but you want to make sure that they create the same association, that it's all one. Based on what you just read, it sounds like they're not. And so that's exactly right. Yeah, so what you have is you've got, let's call it phase 1 association and phase 2 association. And you would treat them as separate entities. They wouldn't share money. They wouldn't.
We don't want two separate entities. We want one entity.
So now.
Our neighborhood has one entrance.
So that.
Our neighborhood shares common space.
Yeah.
Not necessarily by the plots, because it is two separate plots. But
so what you're looking at doing is not only amending your covenants, but also doing a merger.
yeah,
I mean, that's.
And our answer was to go back to the developer and say, can you do this for us? However, according to our covenants, as soon as he sold the last lot, he is no longer the declarant.
That's typically true, yeah.
So by him not being the declarant, by all definition, he no longer has the ability to do that, under my understanding.
And that's probably accurate. I haven't looked at your covenants, but that. So I would look, and if we've confirmed that the developer doesn't own a lot and hasn't just told you that because they don't want to mess with it, I'd look and see if they still hold title to the common area, and if there's if they do still hold title to the common area, then I'd look at the covenant language and see if that gets us to where we want to go. If not, then it's up to the owners to do that amendment and merger.
He doesn't own any lots, but according to the county records, his other association, the Development Association, does still own the common areas.
Now, I don't understand development association. There's one association for this and one association for that.
He had two separate ones, and they are actually in the covenants. One of them is listed as the declarant, but there is another one that's the Homeowners Association.
More than likely, the declarant is the development entity.
Yes.
And it holds title to the common areas.
It holds title to the common area.
Okay, that doesn't create a separate association. That's just the developer owns that land and hasn't sold it like it sold the other lots.
But then can he prevent him from using it? The common area?
Typically, no. Title, when it comes to common area, title doesn't determine who gets to use it. It's common area.
Okay. What is the common area? What is?
You would have to answer that by looking at the plat. The plat typically.
Like swing sets and.
Could be.
Swimming pool for everybody or?
Could be. One of the things that I do in my developer documents is say this is a section line road right here, paved. There's green space right here, commonly called a right-of-way. Oftentimes, that's not platted as common area. It's part of these people's lots, but they can't do anything with it because it's part of the right-of-way. Well, over time, we've found that people have different ideas of what level of maintenance should be had on here. There's folks like me that cows eat grass, mowers don't eat grass, all right? I'm just that guy. And so I don't mow. I let my cows eat our grass. And not in a neighborhood like this. But I'm just illustrating and you know the neighborhood, it's by you, that looks like this. That neighborhood does not have a mandatory association. That neighborhood is right across the street from my Edmond office. The grass is like this, and you've got the one guy out there who, like me, doesn't like to mow, and he is just scalping it. And, that's got the huge dust cloud going up. So what I do is I define that as common area in my covenants. So if you've looked at a set of mine, it'll have a definition that says common area is defined as all the property that the association owns or has management responsibility over, and you get later in the covenants it says the association shall maintain the right-of-way, because that's the first look at the neighborhood. You don't want me mowing that, you want a professional mowing that.
So if it's actually plotted as common area, when you look at the county assessor's records, should that be under ownership of the HOA, or should it be under ownership of the declarant?
Depends on what time frame we're talking about. Because depending on the time frame, that it goes either way. So when the day one, when this plat hits, it should be titled in the developer. It is titled in the developer. After so many of these lots have been sold, that should becomes a little squishy, because to me, as counsel, it doesn't make any difference whether it's titled in the name of the developer or the association. It doesn't matter if the developer holds on and that's the very last piece of property it transfers.
But how is it determined who's actually liable? Or, who's responsible for that? I mean, if it's platted to us as common area, but the developer still owns the title, who's really responsible for that?
And what are you talking about? Responsible for maintaining it? Responsible?
Maintaining it, and also liability, yeah, just liable should someone injure themselves in that
Let's
common
say there's
area.
a pond on it, and a kid goes out there and drowns.
If it's not in...
Mommy and daddy gonna sue, who's mommy and daddy gonna sue? Is he gonna sue the HOA because it's a
Yes.
common area, and it's in the covenants that we're supposed to maintain it?
Yep.
Or is he gonna sue the owner because
It's still not, it's still a developer.
How does holding title increase liability? It doesn't. The association is the entity that's tasked typically under the covenants for maintaining the common area.
So the deed makes no difference is what you're saying.
That's what I'm saying, not to me.
Well, only if the covenants said that the developer holds strict and that's not released to them, to them. So if that was held separate and not included part and parcel in the common area,
I'm not following.
that would be the only way that would work, right?
Well, the only way I could see that there would be an issue is if the covenants say developer shall transfer common area upon the sale of the last lot and the developer held on to it.
there's no language that talks about him transferring anything?
Yeah.
Who's supposed to pay the taxes on that,
Association.
even though it's in his name? If
Yeah.
it's in his name, does he not have the overall authority to do anything he wants with it?
No, it's common area.
Even though it's technically his, because
And that's the thing, is
So the owner of record makes no difference.
I wouldn't go that far, no. But the answer to your question is, the fact that the title is still in the developer's name doesn't change all of the language and the entire structure that is common area. It's the association's responsibility.
And liability.
And liability, except for me, if I was the attorney bringing a claim against the association for the kid that drowns in the pond, I'm going to check title, and the developer's just a bonus baby for me.
He's the one who's got any money in that situation.
he's only got like 62 Buffalo Wild Wings.
May I ask?
But see, the thing is, in that instance, you might drag in the LLC, but you're suing the association who is the developer. Right?
Not
No,
anymore.
not anymore. By
Because all
covenants, he sold every lot, so he no longer is declarant.
And again, this kind of gets back to the board that's refusing to file an 1120H. What you're telling me is oftentimes a developer that doesn't know they're still in title, that is clueless. There is no reason for the developer to hold on to that title. It's common area. You get rid of it. I mean, it's not a hot potato, but
He tried selling it at one point.
and that just tells me you've got a developer that doesn't get it.
Luckily,
Doesn't.
the guy on lot phase 3, who I believe was smart enough to say, I can't buy that. It doesn't belong to you.
No kidding.
Once it's a common area, it's always common area. It's always going to be common area.
Oh, you could.
Can't build, I mean, nobody could buy it, and do what they wanted to with it.
You could replat it. Yeah, so for example, there was an investor, this has been a long time ago, that was scooping up common area at tax sales. you're aware if you don't pay your property taxes, it will go to a sale, and then all those late night TV folks will pick it up for pennies on the dollar. And so a couple of associations that I represented got these letters from this developer that said, I've got your common area, I'm going to build condos or something, houses on them unless you pay me. And our response was, thank you. And actually, I'm kind of talking out both sides of my mouth now. So we told this guy, thank you. Now that you own this, you can pick up the maintenance responsibility. You can pay the taxes, the insurance. And by the way, you can't build condos on there because they're not lots, they're common areas. And it was like, they just, they get rid of this title quickly, immediately. And we didn't litigate any of those, but it's common area. It's not trust lands, but it's not a lot. It's not inventory that you can buy and sell to phase 3 buyer. It's not a lot you can build a house on. It's common area. Now, where it might get a little fuzzy is if we have maybe some drainage areas, private drainage areas listed on the plat, and maybe it's unclear whether the association controls those or whether the individual lot owner. Now maybe we might have some dispute on, okay, we've got defined common area, but it's on owner's land. There's a development in Edmond that went in recently where the city of Edmond approved these drainage areas and including ponds, and the association is to maintain those, but it's private property. And it's a little bit of a unique use of land. But generally speaking, whether this is titled in the name of the developer or titled in the name of the association or titled in the name of late night TV investor, it's still common area. And it's still subject to the same covenants, the restrictions. It's all of that language that says nothing shall be done for, or nothing shall be done on the common area that's a nuisance, or whatever the covenant language is. Title doesn't change that, okay? All right, well, we are out of time for this week. We will cover next week in-depth enforcement. We'll go over the ins and outs of different kinds of enforcement. I've got a little bit more to say on amendments, some of the nuts and bolts, and how to make that project a little more manageable. We'll talk about the finances, talk about assessments, the different kinds of assessments, what to do, what to watch out for with assessments. So we'll see you next week. Thanks.